The state's top court heard arguments late last week on the constitutionality of Albany County's cyberbullying law. We're joined by our legal analyst, Paul Harding of Martin Harding Mazzotti. Morning, Paul.
Good morning, Chuck. Good morning, Kelly.
Good morning.
So it seems like the high court, it seemed obvious to me anyway, correct me if I'm wrong, was pretty obvious that it has some big problems with the law.
Yeah, if you're the attorney arguing for the law, you left that courtroom not feeling very good. You've got a situation here where, historically, let's go back just a bit, you've got this speech as a crime. The classic argument was yelling fire in a movie theater, right? Causing havoc with your words, or maybe even bringing about violence, starting a riot with your words. And things have progressed since then, but what I'm looking at based on the judge's questioning of the Albany County attorney is, I think they're going to look at this statute and say it's a little too broad. It's going to really limit First Amendment and also make it potentially unfair to enforce. So he's sort of sending the message, hey, this law is not so good. We're not saying we wouldn't approve one, but maybe not this one.
Are there other laws that already cover what this is trying to do?
There are. You've got harassment. You have that being the basis where the attorney for the Civil Liberties Union, which was opposed to the law, saying, hey, you have stuff on the books here. You have things that will qualify as criminal if they go to a certain level, if there's an intent to harm. And that is true. It's on the books. But now we're entering into a new phase, right? We've got the Internet, and we got in this situation, we had a kid who put up this fake Facebook page or anonymous Facebook page and really kind of dug into some students pretty hard, getting into their sexual orientation, getting into some of their habits. And they're saying, hey, we think we need to kind of stop this. And I think the public would sort of agree that there needs to be something. And Judge Lippman sort of threw a message out there. He said, just kind of change this a little bit. The word harass and annoy. So if you harass and annoy someone, it's just so broad. I mean, this phone call could be, if it went on and we had some comments, it might be harass and annoy. I could send you an email. Mm-hmm. You said, well, Paul, that was sort of harassing. And, it just kind of annoyed me what you said. And does that fall under the statute? Because the way the statute was originally written, it wasn't even just children. It was virtually anyone. It could happen in an office place. So I suspect the statute is going to go away, and then they're going to rewrite one that is less broad. The issue being, again, we're a state that's out there on the front of the race here. There's no one else who's really successfully had a cyberbullying law.
Yeah, and the one you brought up something I was going to ask. The fact that I heard the judges say this would apply to adults as well as children, and the intent of this thing was to protect children. Could they craft something that would hold legal water that would just, apply to minors, or is there still do minors still have free speech rights too?
That's going to be a problem too. Yeah, I mean, the intent, they want children protected, but unfortunately, everyone has equal rights of protection under the law. So, but they can limit the age, but not just say children. They do have laws that protect children under a certain age, and that's what they're going to have to do. But again, it's not going to be easy, and I suspect with whatever they craft, they're going to be back in the Court of Appeals with that law.
All right. Paul Harding. Thanks so much, Paul. We appreciate it.
Okay, guys. Thanks.
1-800-LAW-1010. Paul Harding of Martin Harding Mazzotti.